I've seen a lot of people making immigration mistakes lately, and let me tell you about a story from a consultation I had last week. So this guy is a US citizen, he's been living here his whole life. He was actually born here, but he has a sibling who was born outside of the US and who entered the US as a tourist and then ended up overstaying. So the US citizen sibling filed a family petition for the immigrant sibling several years ago, and it's still pending, although it should get approved sometime soon. And so they came to me and they said, why doesn't my sibling have his green card yet? And that question just, made my head kind of explode because there were several things wrong with this scenario. First of all, this brings me to the discussion of preference categories versus immediate relative category petitions. If you've overstayed a tourist visa or student visa or any visa, if you're out of status in the US, you cannot benefit from an adjustment of status application, a green card application, unless you have a US citizen spouse or a US citizen child who's over age 21, or if you're a child yourself, you need a US citizen parent who petitions for you. These are the three categories of petition that are referred to as immediate relative petitions, which will allow you to cure your unlawful presence in the United States and become a permanent resident. So you'll notice in these categories, there was no mention of a sibling petition. Sibling petitions are particularly useless in immigration law because, first of all, they take like 16 years before you can continue with the case, before a visa becomes available, before you can apply for permanent residence. But also, they are not immediate relative petitions. They are considered preference category petitions, which means you cannot be unlawfully present in the US if you want to benefit from this. And number three, in the scenario I gave, they never filed a green card application. So there was not even an application for permanent residence pending, which was correct because if they submitted a green card application, it would be promptly denied for like 3 separate reasons. Now here's another scenario. A US citizen husband files an I-130 family petition for his immigrant wife who overstayed her tourist visa and is currently inside the United States. And they come to me and they ask me, why is the green card taking so long? The I-130 just got approved, but no green card arrived. Well, the answer is because you never submitted a green card application. An I-130 family petition is only a prerequisite for becoming a permanent resident, either through adjustment of status or through consular processing abroad at a US embassy or consulate. An I-130 by itself confers no immigration benefit. It will not lead to employment authorization by itself. It will not lead to permanent residence by itself. For either of these benefits, you would need to submit a separate application and make sure you are eligible. On this note, I cannot tell you how many times I've seen people who have approved I-130 petitions who are not eligible for adjustment of status. Let's take the first hypothetical story I told today, where someone filed a sibling petition. That sibling petition will eventually get approved, but that doesn't mean the sibling's eligible for permanent residence because they are unlawfully present in the US. And if you're unlawfully present in the US, you cannot benefit from a sibling petition. You can only benefit from a spouse petition or a parent filing for a child or a child filing for a parent. Those are the only 3 categories of immediate relative petitions that would benefit you if you are out of status in the United States. Before I end this video, I just want to make one quick point. If you are the beneficiary of a sibling petition, or you're an adult and your US citizen or permanent resident parent filed for you and it's taking like 8 to 13 years to process, or in some other category of preference petition, not an immediate relative petition, there might be a way still for you to become a permanent resident. It might involve you applying for an unlawful presence waiver and then going to the consulate abroad for your interview so that you can re-enter the US as a permanent resident. It's a case-by-case determination depending on the facts of your specific case. If you need assistance with any of these matters, or you have any questions on what to do, or you have a petition pending and you're wondering if you'll be eligible for permanent residence once it gets approved, schedule a consultation with me. I would love to speak with you and your family about your case and assist you if you need additional assistance after the consultation. If you're new to my channel, I try to put out weekly videos on family-based immigration, naturalization, and policy changes that we're currently experiencing under the Trump administration. If you're interested in these topics, be sure to subscribe, and I'll see you guys next time for another video.